Good morning. This hearing of the Subcommittee on the Constitution, Civil Rights, and Civil Liberties will come to order. Today's hearing will continue the Subcommittee's oversight of the Civil Rights Division of the Department of Justice. Today, the Subcommittee will focus on the work of the Employment Section of the Civil Rights Division. The Chair now recognizes himself for 5 minutes for an opening statement. Before we begin, I would like to take note of the fact that today is the 50th anniversary of the integration of Central High School in Little Rock, Arkansas. When those 9 brave students walked into that school, they made a mark on American education and paid tribute to our civil rights. 50 years later, while discrimination has been erased from most of our laws, it has yet to be fully achieved in our actions. It is partly through the work of this subcommittee, the full committee, and Congress that I hope we can soon see the day where equality is found both in our hearts and deeds. Deny an otherwise qualified person a job, and you deny that person dignity, the ability to feed his or her family, possible health insurance, and all the necessities that go along with gainful employment. Deny someone a job the person has trained for or has worked at for many years, and you are destroying what might be a lifetime of work. One of the most important missions of the Department of Justice is to protect all Americans against employment discrimination on the basis of race, religion, gender, disability, or national origin. Hopefully, in the not-too-distant future, we will add to that list sexual orientation and gender identity, but that is a battle for another day. Today, we are concerned with how well the Department of Justice is enforcing the present law. In many other areas, this committee has brought to light decisions made at the Department of Justice that seem to have been guided more by political considerations than by the merits of an issue. Sometimes it is not so much politics as ideology. Today, we will examine a number of cases in which the Department seems to have gone against established civil rights policy or even turned its back on consent decrees to which it had committed itself. As in other parts of the Department, we have received reports of poor morale, departures of career staff, and political interference with the section's important work. I'm concerned that this pattern may also be present in the employment section. The Justice Department's Employment Litigation Section is mandated to enforce Title VII of the Civil Rights Act of 1964 and various other civil rights laws that prohibit employment discrimination. As challenges to discriminatory employment practices are usually factually and legally complex and often take several years to litigate, the Justice Department is uniquely positioned to lead the charge in those cases. The Bush administration, however, has filed only 47 Title VII cases since 2001. By comparison, the Clinton administration filed 34 cases in its first 2 years and a total of 92 by the end of its term. Also, in many cases, the current Justice Department has reversed the position taken by all previous administrations in the middle of a case or has opposed settlements to which the Department had previously been a party. One of the witnesses has been a victim of discrimination in such a case and will describe her experiences. Also at issue is the exit of a significant number of career lawyers in the section and the hiring of lawyers who have little experience in civil rights. There is nothing more un-American than bigotry. When those charged, or maybe we should say that there's nothing more typical of history, both in America and elsewhere, than bigotry, but we want to make it very un-American. When those charged with fighting discrimination fail to do so, the government provides tacit support for discrimination. Discrimination destroys families and tears at the fabric of our nation. We are at our strongest as a people when we use the talents and abilities of all our citizens to their fullest extent. To that end, the enforcement of our discrimination laws must be above partisan and political influence. The promise of our nation's civil rights laws is only met when the Justice Department applies them aggressively and in an even-handed fashion. We will examine today whether that promise is being kept by the current Justice Department. I look forward to our witness testimony, and I thank you for being here to testify. I would now recognize our distinguished ranking minority member, the gentleman from Arizona, Mr. Franks, for his opening statement.
Well, thank you, Mr. Chairman, and thank you, Mr. Agarwal. Appreciate you being here. You know, among other things, the Employment Litigation Section of the Department of Justice enforces against state and local government employers the provisions of Title VII of the Civil Rights Act of 1964 and of other federal laws prohibiting employment practices that discriminate on the grounds of race, sex, religion, and national origin. And I look forward to the testimony today, as I, like all of us here, want to be assured that the employment section is adequately enforcing these essential civil rights laws. The litigation handled by the section is of national importance. as it speaks to the principles that define America's kindness, compassion, and core essence. Its attorneys are to be commended for their tireless dedication to enforcing the law, which extends to every corner of complex litigation, from investigations to filing motions, from settling negotiations to trials, from the monitoring and enforcement orders to the securing of remedial relief. I am particularly encouraged that the employment section appears to be putting forth appropriate resources into the prosecution of religious discrimination cases. In the United States v. Los Angeles Metropolitan Transit Authority, for example, the section alleged that the MTA was engaged in a, quote, pattern or practice, unquote, of religious discrimination by not reasonably accommodating employees and applicants for employment as bus operators who, in accordance with their religious beliefs, are unable to work weekends. In another religious discrimination suit, the United States v. New York Transit Authority, the section alleged that the New York Authority has engaged in a pattern or practice of discrimination against Muslim and similarly situated employees who wear religious head coverings by not reasonably accommodating their religious beliefs and by selectively enforcing its uniform policies. Mr. Chairman, religious freedom is at the core foundation of all other freedoms. And though America often fails to enforce the laws protecting against religious discrimination as we should, we still do it better than anyone else in the world. And I believe that the even-handed defense of religious freedom across the board of all religious perspectives is vitally important and, again, is at the core of who we are as Americans. The employment section is also has enforcement responsibility for the Uniform Service Employment and Reemployment Rights Act of 1994. As a member of the Armed Services Committee, I believe it's essential that the employment rights of those who serve in the military are protected with as much vigor as our men and women in uniform apply in defending all of us. The Uniformed Service Act protects veterans of the armed services when they seek to resume their jobs upon returning from serving the United States in some foreign battlefield or otherwise. And it helps guarantee that they will return to their civilian positions with the seniority, status, rate of pay, health benefits, and pension benefits they would have received if they had never left. I understand that in fiscal year 2006, the employment section filed 4 complaints in federal district court and resolved 6 cases under the law. I look forward to hearing about those cases in more detail, and I'm pleased to hear that the Department of Justice recently launched a website for service members, www.servicemembers.gov, that explains the rights of service members under this law as well as their rights under the Uniform and Overseas Citizen Absentee Voting Act. And with that, I look forward to hearing from all of our witnesses in defense of religious freedom. Thank you, Mr. Chairman.
Thank you. In the interest of proceeding to our witnesses and mindful of our busy schedules, I would ask other members to submit their statements for the record. Without objection, I'll revise that. The chairman of the full committee will now be recognized.
Thank you, Mr. Chairman, and to the ranking member, and to my friend from California who joins us on this very important morning. The reason I want to use a few minutes to make an opening statement is that we have a political deputy assistant, Mr. Agarwal, who we welcome, but the person we probably should have had was Attorney Kay Baldwin. And I regret that Mr. Agarwal is going to have to take the burden for her, because the department's in pretty bad shape. Lots of people leaving, lots of people being moved around. But the enforcement priorities at the employment section have taken a dangerous turn. we're left to grapple here with allegations of partisan politics that have infected both the hiring, the promotion, and the substantive work of the section. Even the most cursory glance at the section's docket, as outlined by the chairman and detailed in written testimony, shows the marked decline that Mr. Nadler has referred to in the enforcement of employment discrimination laws. The only thing I can think of is that this section, like the department, thought they would never be oversighted and called to be held in account this morning for what's going on over there. That's the only thing I can think of that would have such a dismal retrograde record of non-accomplishment. It's absolutely shocking, and the administration has turned against parties it formerly assisted and taken directly adverse positions in the same litigation. Now, while it's important to protect the rights of all Americans, I'm troubled by this significant decline of Title VII litigation on behalf of African Americans and Latinos, as demonstrated by the docket. 7 cases on behalf of African Americans and Latinos out of 3,200 referrals for prosecution from the Employment Board. This is inexcusable, and over the last decade, there's been an assault on progressive enforcement of employment discrimination laws. The premise behind the retreat is that discrimination in our society has supposedly receded. However, any review of the evidence indicates that discrimination continues to still be persistent and widespread. And while the nature of this discrimination has changed, moving from de jure form in the old days when segregation was openly sanctioned to the more subtle de facto form of the same problem in the 21st century. If you look at the actual evidence in critical areas such as employment, housing, education, and most notably our justice system, you'll see there's an overwhelming evidence of ongoing discrimination in our society. With regard to employment, the Bipartisan Glass Ceiling Commission found that nearly all, 95% of the top corporate jobs in America are held by white males, with African Americans holding less than 1% of top management jobs, women holding 3 to 5% of senior level positions. Black unemployment has also been found to be twice that of white unemployment in our national statistics. A recent study in which college students posed as job applicants found that a white male with a criminal record had better employment prospects than a black man with no record whatsoever. The disadvantage carried by a young black man applying for a job as a dishwasher or a driver is equivalent to forcing a white man to carry an 18-month prison record on his back. The American public has also has few illusions about employment opportunity, a Gallup poll. Do you feel that racial minorities in this country have equal job opportunities as whites or not? Among whites, the answer was 55% yes. Among blacks, the answer was 17% yes. Prior to this Congress, there's been virtually no scrutiny of the problem of remedying employment discrimination. And so the real question facing the committee today is how to secure an effective role of the department in eliminating the underlying causes of employment in the 14 months or so that we have left. And I will submit the rest of my statement for the record and thank the chairman for his courtesy.
Thank you. In the interest of time, we would encourage other members to submit their statements for the record, but I will recognize Mr. Isa's requested recognition.
Thank you, Mr. Chairman, and I'll be brief. I want to associate myself with the ranking member, particularly on the issue of the most basic of all the enforcements that we need done by our government, and that is support of the First Amendment, where Congress shall make no law respecting the establishment of religion or prohibiting the free exercise thereof. In fact, we often hear the First Amendment talked about in terms of freedom of the press, and not, in fact, the freedom of people to practice their religions and to be free from employment discrimination for practicing those religions. So as we go through this process, I'd like to, one, associate myself with the ranking member, and two, distance myself from the chairman of the subcommittee, who clearly has an agenda at a time in which the full committee chairman says we're not doing enough about Latinos and African Americans, meaning we're not doing enough about those who may be discriminated based on race, who wants to add sexual persuasion, orientation, and the like, those which are by no means spoken of in the Constitution or by current law. So I would encourage this committee to focus on ensuring that those which there is uniform agreement on must be enforced. Race, religion, national origin, be strictly enforced. And until we can get to where this committee on a bipartisan basis believes a good job is being done, we should not tread onto territory that is by definition filled with new opportunities to fail in enforcement. And I thank the chairman for yielding the time, and I yield back.
All right, I thank the gentleman. I would encourage the gentleman to join me and others then in getting the Department of Resources to deal with all the discrimination so they don't have to choose between religion and racial discrimination. Without objection, all members will have 5 legislative days to submit opening statements for inclusions in the record. Without objection, the chair will be authorized to declare a recess of the hearing. Hopefully, we will not do that. We will now return to our witnesses. As we ask questions of our witnesses, the chair will recognize members in the order of their seniority on the subcommittee, alternating between majority and minority, provided that the member is present when his or her turn arrives. Members who are not present when their turn begins will be recognized after the other members have had the opportunity to ask their questions. The chair reserves the right to accommodate a member who is unavoidably late or only able to be with us a short time. Our first witness today is Asheesh Agarwal, I hope I've pronounced that correctly, one of the Deputy Assistant Attorneys General who report directly to the head of the Civil Rights Division at the Department of Justice, Acting Assistant Attorney General Rena Johnson Komisak. Mr. Agarwal is a 1997 graduate of the University of Chicago Law School, and we welcome him here today. Welcome. Your written statement will be made part of the record in its entirety. I would now ask that you summarize your testimony in 5 minutes or less. To help you stay within that time, there's a timing light at your table. I'm sure you're aware of that. When 1 minute remains, the light will switch from green to yellow and then red when the 5 minutes are up. Before we begin, it's customary for the committee to swear in its witnesses. If you could please stand and raise your right hand to take the oath. Do you swear or affirm under penalty of perjury that the testimony you're about to give is true and correct to the best of your knowledge, information, and belief?
I do.
Let the record reflect that the witness answered the affirmative. You may be seated. Sir?
Thank you. Mr. Chairman, Ranking Member Franks, members of the subcommittee, it is a pleasure to appear before you to represent President Bush, Acting Attorney General Keisler, and the dedicated professionals of the Employment Litigation Section of the Civil Rights Division. I am pleased to report that the division continues to vigorously combat employment discrimination using all of the provisions of Title VII on behalf of all Americans. Those provisions include both Section 707 of Title VII, which bars employers from engaging in a pattern or practice of discrimination, and Section 706, which bars individual acts of discrimination. The division has been extremely proactive in using Section 707. Thus far, in fiscal year 2007, we have filed or authorized 3 pattern or practice cases. We also resolved another suit under Section 707 on behalf of African American and Hispanic employees. In fiscal year 2006, we filed 3 more complaints alleging a pattern or practice of employment discrimination and obtained settlement agreements or consent decrees in 6 other cases. Therefore, in the past 2 years, we have filed 6 pattern or practice cases and resolved 7 others under Section 707. These cases include some very significant ones that have the potential to benefit a large number of employees. On May 21st, 2007, we filed a Title VII lawsuit against the largest fire department in the country, the Fire Department of New York. Our complaint alleges that the City of New York's use of written exams discriminates against blacks and Hispanics in the hiring of entry-level firefighters. As outlined in our complaint, FDNY employs 11,000 uniformed firefighters. However, only about 3% of those employees are black, and only about 4.5% are Hispanic. Our suit seeks to force the city to end discrimination against black and Hispanic firefighter applicants. We also seek remedial relief for those firefighter applicants who have been harmed by the city's use of the challenge exams. We recently obtained such relief in another significant lawsuit. On June 8th of this year, the department announced the settlement of a lawsuit against the city of Chesapeake, Virginia. Like the FDNY suit, this lawsuit alleged that the city's use of a math exam unlawfully discriminated against black and Hispanic entry-level police officer applicants. Under the terms of the settlement agreement, Chesapeake will create a fund to provide back pay to African American and Hispanic applicants who are denied employment solely because of the city's use of the math test as a pass-fail screening device. The city will also provide priority job offers for African American and Hispanic applicants who are currently qualified for the entry-level police officer job, but were screened out solely because of their performance on the math test. In addition to Title VII, the section works closely with the Department of Labor to vigorously enforce the Uniformed Services Employment and Reemployment Rights Act, or USERRA. USERRA protects the employment rights of our brave men and women serving in the armed forces. In fiscal year 2006, the division filed 4 USERRA complaints in federal district court, including the first USERRA class action complaint ever filed by the United States. We also resolved 6 USERRA cases. Thus far, in fiscal year 2007, we have filed 5 USERRA complaints in district court and resolved 5 other cases. One particular case highlights the importance of USERRA. In the case of McKeague versus Town of Stewartston, New Hampshire, Staff Sergeant Brendan McKeague had been employed as the chief of police for the town of Stewartston. While Staff Sergeant McKeague was on active duty in Iraq, the town sent him a letter telling him that he no longer had his job with the town. When the citizens of Stewartston learned that their chief of police had been terminated while serving his country abroad, they voted to censure the town for its, quote, illegal and outrageous conduct. Despite this public censure, the town still refused to reemploy Staff Sergeant McKeague into his former position. After we learned about this case, we notified Stewartston that we intended to sue. Once we did, the town decided to settle the case, and the settlement terms include a payment to Staff Sergeant McKeague of $25,000 in back wages. This case, and similar cases, demonstrate the continued need for this important statute. As all of these cases indicate, the Civil Rights Division has vigorously enforced and will continue to vigorously enforce the provisions of Title VII and USERRA. The division looks forward to continuing to work closely and cooperatively with this committee in its effort to combat employment discrimination on behalf of all Americans. Thank you, and I look forward to your questions.
Well, thank you. We'll start by the chair granting himself 5 minutes. Mr. Agarwal, in the Burlington Northern and Santa Fe Railway Company versus White case, the department urged a very narrow interpretation of Title VII's anti-retaliation provision, contrary to the EEOC's longstanding interpretation. Ultimately, when the case went to the Supreme Court, 8 justices, including Justice Alito, with the exception only of Justice Alito, rejected the department's reading as inconsistent with Title VII's plain language and its underlying purposes. How do you reconcile the department's position in this case with the Supreme Court's decision, and what was the basis of the department's decision to reject the longstanding EEOC interpretation of the scope of the retaliation provision under Title VII of the Civil Rights Act, a rejection by the department, which was then repudiated by the Supreme Court?
Thank you, Mr. Chairman. The department determines its position through the Solicitor General by analyzing the statutory language, the case law, and the legislative history. In that case, at the time we filed our brief, 6 circuit courts of appeals, including a majority of all circuit courts of appeals that had addressed the issue, agreed with the position taken by the department. Justice Breyer, in his majority opinion, acknowledged that it was a very close case, and Justice Alito, in his concurring opinion, noted that it was very difficult to reconcile Sections 703 and Section 704 of Title VII. In addition, I would note that the Supreme Court reached the same result advocated by the United States, albeit on different grounds.
But the interpretation stands differently now, back where the EEOC left it, where the EEOC had urged it.
It is correct, Your Honor, that the Supreme Court decided the case on different grounds than had been advocated by the United States.
And we're back with the EEOC interpretation as preceding.
That's correct.
Thank you. During this administration, the EEOC has referred over 3,200 cases of discrimination under Title VII. Yet of these cases, the DOJ has filed suit in only 7 cases. Why so few? 7 out of 3,200.
Thank you, Mr. Chairman. I think if you look, I think you need to put those numbers into historical context to fully appreciate what they mean. During the last 4 years of this administration, we have filed suit on between 1% to 2% of EEOC referrals sent to us. That is the same percentage as were filed during the last 4 years of the Clinton administration.
And yet, as I referenced in my opening statement, the number of cases has gone down rather drastically.
Again, I think to fully appreciate what those numbers mean, I would urge the committee to also look at the success rate that the department has had. In our cases, we have prevailed in every pattern and practice case, with one exception.
I haven't gotten to pattern and practice yet. We're talking about individual cases for the moment.
Sure. And again, I think if you put those numbers into historical context, we're doing about as much in terms of filings as our predecessors. And I would also note.
No, but wait a minute. You file 1% to 2% currently and historically, you're saying,
yes,
of the referrals by the EEOC.
That's correct.
And yet the number of referrals, the number of filings has gone down considerably. Given the fact, I mean, 1% to 2% sounds like an awfully low number. If the number of referrals has gone down, which is essentially what you're saying, so it's only 3,200, maybe it was, I don't know what it was before, 4,000, let's say. Shouldn't you then have the resources to up the percentage to go to 3%?
Well, I'm not sure that it's a resource issue, Mr. Chairman. Since joining the division last year, I've made it a priority to have the employment litigation section reach out to the EEOC to determine if there are ways in which we can improve our already good cooperation. One of the first things that I did upon joining the division was to reach out to Naomi Earp, who is the chairwoman of the EEOC, and during the course of the last year, members of the leadership of the section have flown around the country to meet with EEOC regional attorneys to determine if there are ways that we can increase this.
Let me ask you one question before going on to pattern and practices. Why is it that under this administration and previous administrations, only 1% to 2% of cases are filed of those referrals that the EEOC thinks are legitimate cases? If it's not a resource question.
That's a very good question, Mr. Chairman. And I would note that the EEOC itself only brings suit on a relatively small percentage of charges that are filed with it.
Well, but that's not an answer.
And not all of the cases on which the EEOC finds reasonable cause end up being suit-worthy after.
Yeah, but 1% or 2%. But 1% and 2%.
Those are what the numbers have been historically. And after further investigation has been done, sometimes we find that they're just simply not appropriate.
All right, my last question is, the employment section has brought very few Title VII pattern and practice cases. On average, you filed about 1/3 fewer pattern and practice cases in the previous administration each year. Given that employment discrimination is still a significant problem, Why has the number of pattern and practice cases gone down by about a third?
Again, Mr. Chairman, I would take issue respectfully with that characterization. We have filed during this administration, on average, 2 pattern and practice cases a year. That's the same average as happened during the last 4 years of the Clinton administration. In addition, we have filed 3 pattern and practice cases within the last fiscal year and 6 within the last 2 fiscal years. During the last 3 years of the Clinton administration, they filed 3 pattern and practice cases total. So in the last 2 years, we managed to double that amount.
We'll get back to those statistics later, but my time has expired. I recognize the ranking member of the subcommittee, Mr. Franks.
Well, thank you again, Mr. Chairman, and again, Mr. Agarwal, thank you. You know, I suppose one of the dark marks on any nation is the practice of discriminating or abrogating the civil rights of their fellow human beings within society. And that's also true of the United States, you know, especially since the very core essence in which we were founded is that we held certain truths to be self-evident, that all men were created, and women, and that this is what made them equal. And I find that the great tragedy somehow in civil rights discrimination is that somehow the intent is to miss the miracle of each human being, and that somehow to forget that each person is a child of God. And what concerns me is that somehow we have forgotten that you know, as 2-year-olds understand, they can be a colorblind society. They are fascinated by one another's differences, but never are they instigated toward discrimination or toward diminishing each other on that basis. So I guess one of the things that disturbs me a little bit is this, this term reverse discrimination. It's a hard one to address. But I guess first of all, I want to ask a really hard thing of you. Can you define reverse discrimination for me?
I think as that term has been used, it refers to discrimination against white Americans, yeah. Caucasians.
Yeah. Well, I think you're right, obviously, but I think that I would maintain that the reverse discrimination is kind of a misnomer that should be discarded, because first it suggests that a member of the majority cannot be, cannot suffer discrimination, and it's, of course, that's not true. The chromosomes that one inherits, whether black or white or otherwise, and the percentage of similarly born individuals should not determine the extent of one's protection under civil rights laws. And I know that your office has recognized that. The reason I believe that's so important is because if we can truly look at this on the basis of a totally colorblind perspective, I think therein lies the hope of somehow, someday, making your office totally unnecessary. And I hope that we can do that. Do you agree, obviously, that all Americans, even those that are of a predominant race or religion, should deserve equal protection under the law?
Absolutely, Ranking Member Franks.
So let me just give you a snowball question here and ask you if you could give us an overview of the cases that you prosecuted regarding religious discrimination over the years.
Thank you for that question. We have filed 4 pattern and practice cases alleging religious discrimination during this administration. In your opening statement, you referenced our case in Los Angeles. I will also tell you a little bit more about our case that's pending against the New York Transit Authority. In that case, New York had a policy of allowing individuals to wear head coverings, turbans, khimars, baseball caps, prior to September 11th. After the events of that day, they changed their policy to selectively enforce it. So after the change in policy, individuals could wear baseball caps, for example, but they couldn't wear turbans or khimars. And it is our position that they have been unable to justify that selective enforcement. And we think it's particularly important after the events of September 11th to enforce Title VII's prohibitions on religious discrimination, certainly on behalf of all Americans, but in particular on behalf of Muslim Americans.
Mm-hmm. Do you see any, are there any emerging trends or patterns that seem to be changing in the whole enforcement mechanism? What do you see out there as far as trends that you either find encouraging or ominous?
Well, we are actually very encouraged by the level of cooperation we have received from Muslim and Arab groups. We have very good We've had very good outreach with those groups, and we feel like we have a very good pipeline of information such that if any members of those groups feel like they're suffering discrimination, they're able to call the Civil Rights Division and get a prompt response. We have monthly meetings with those groups, and we like to feel that we're on top of it.
Well, Mr. Agarwal, I guess I would just end with a sort of a narrative a little bit on the situation we have in Guantanamo. I know it seems completely unrelated, but I find it unique that in the United States, in a prisoner of war camp, that we paint arrows on the floors there at taxpayer expense, aiming toward Mecca. We have a taxpayer-funded a system for the PA there that people can have their prayers broadcast 5 times a day for 20 minutes. We bring in special food for their religious practices. We buy prayer cloth, we buy prayer rug, we buy the Quran that can only be held with rubber gloves. We do a great deal to try to accommodate religious freedom, and I think that's altogether appropriate, because if we forget as a people that religious freedom is at the core of the rest of our freedoms, then I'm afraid we'll lose them all. Thank you, sir.
Thank you. Before I call on the chairman of the committee, let me congratulate you on the head covering case against the New York City Transit Authority. But I also ask you, what is a kimar?
A kimar is a head covering worn by Sikhs,
Oh, okay.
people of the Sikh faith.
Thank you. I now recognize the distinguished chairman of the full committee, Mr. Conyers.
Well, Mr. Chairman, this is one of the more amazing hearings I've ever been before, attended and participated in. Now, I'm being explained by this deputy that not only is everything okay, but it's the way it went during the Clinton administration. So, you know, we should all be proud of the job you're doing. I mean, if I find this an incredible hearing on that basis. And I've got 1, 2, 3, 4, 5, 4 questions that are based on cases that have come out of this section. But clearly, we're either going to have some more meetings off the record or informally, not hearings like this where there's the 5 minutes back and forth. Now, it's been my impression for years that employment discrimination has been under-prosecuted, left unattended, ignored, and now on the 25th of September, I am told that really, Congressman, wherever you got those impressions, everything is really not only okay, but it's like it was during Clinton. Well, let me tell you something. The Clinton administration didn't leave me breathless either. So telling me that you're not any worse than they are does nothing for me whatsoever. I mean, let me make that very clear. So what this hearing devolves around now is either your section has been, unbeknownst to the chairman of this committee, been doing a pretty good job, because we're not here to demand that you become superlative if you're doing okay. We would encourage you. But you're telling me that things aren't as bad as most people think they are, especially the people who are discriminated in this case, that they just don't understand. And so far, listening to this hearing, I don't think they're going to understand. But I have a responsibility to get to the bottom of this. And so what I want to suggest is that this subcommittee and all those interested meet with you and all the people in the first row or others, so that we really begin to learn what's really coming off here. For us to be arguing back and forth and talking about reverse discrimination should be analyzed in a color-free society. I don't know, what zone that takes me out to, but this finding of reverse discrimination is just absolutely mind-blowing. I mean, we're now having cases coming forward where white people are being racially discriminated against, frequently by a minority person themselves. I find all of this totally unacceptable. I'm going to leave you the questions I would have presented for you to send back in writing. But Chairman Nadler, we've got to get to the bottom of this. And I'm not sure if this mechanism, because members have to feel inclined to do their little political defense or attack or whatever it is. We do that little dance and nuanced terminology. But we're in a society where we don't even have a full employment system in America. I mean, our country is being ravaged by growing numbers of people that, one, don't have a job, but growing numbers of people that have a job that are afraid they're not going to have a job, not through discriminatory practices, but through economic policy. We have growing numbers of people that desperately need part-time work. And poverty gives way to a lot of social maladjustment in our society. Poverty deals with lots of, is the source of lots of problems. Dr. Paul Farmer calls it the pathologies of power, of people that are locked in and can't get out. And we're meeting here with a great attitude that our records are great. We're working hard as anybody that you've ever seen over there. And so we should be happy about it. I am very, very dismayed about this. And I propose to meet with the members of this committee and its chairman to determine how we really do that. To tell me that you prosecuted 6 out of 2,300 cases, referred for possible prosecution, and say, well, that's as good or better than anybody that preceded us. That's not a good answer. That's unacceptable to me. We're trying to eliminate discrimination based on race or sex in this country, and we can't do it by defending in this kind of way. So I thank you for your kind attention and hope I will gain your cooperation after this hearing.
Absolutely, Congressman.
Thank you. And now recognize for 5 minutes the gentleman from Ohio, Mr. Jordan.
Mr. Chairman, I appreciate it. I'm fine at this time. I'll yield time to our ranking member if he'd like, but if not, I'm fine.
The gentleman yields back. I'll now recognize the gentleman from Alabama for 5 minutes.
Thank you, Mr. Chairman. Let me make sure I'm pronouncing your name right, sir. Is it Agarwal?
Agarwal.
Thank you, Mr. Agarwal. Let me pick up where my chairman left off and where the chair of the subcommittee left off. Let me try to put these numbers in some perspective. How many times in the Bush administration era, since 2001, has the Civil Rights Division of the Department of Justice brought an action against a Fortune 500 company?
With respect, Congressman, the employment litigation section has jurisdiction over state and local employers. So
you have no jurisdiction over private employers whatsoever?
Our jurisdiction over private employers is limited to USERRA.
Okay, I was not aware of that. Well, let me shift to another question then. What about criminal prosecutions? What is the most significant criminal prosecution that your department has brought, in your opinion?
Congressman, we've brought a number of criminal matters as part of our cold case initiative to examine civil rights era murders that took place. I should note, however, that I don't oversee our criminal section, so my knowledge of that area is somewhat limited, with apologies, Congressman.
What about voter suppression cases under the Voting Rights Division, cases where there's an effort to suppress or to thwart someone's capacity to exercise the right to vote? Has the department brought a single case that fits that category?
Again, with respect, Congressman, cases such as that would be within the purview of the, typically would be within the purview of our criminal division, and I'm just not up to speed on those figures.
Well, I think you're the third individual from the administration who's testified in my limited tenure on the committee, and I've asked the voter suppression question 3 times, and the answer I've gotten each time has been check with somebody at another desk.
Congressman, I'll be happy to take that question back to the department, and we'll get an answer for you.
Let me pick up another area. One of the criticisms that, as you know, have been raised is that there's been some tendency on the part of the department to change positions, to have taken one set of positions and then to have changed it, to have decided that, well, we initially thought this was an example of discrimination, and then to decide, no, we no longer think that. Let me turn to one case the Supreme Court ruled on 2 years ago, Burlington Northern and Santa Fe Railway versus White, retaliation case. The issue in the case, as I understand it, is the scope of the retaliation clause in Title VII. You're aware of that case, Ms. Agarwal?
Yes, sir.
As I understand it, the Justice Department took a narrow interpretation, did it not, of what the retaliation clause meant? Is that a fair interpretation?
Yes, sir, it is. We took a slightly narrower rationale than was adopted by the Supreme Court.
You took a narrower rationale than the EEOC had typically adopted?
That's correct.
And the Supreme Court ultimately rejected the department's position?
That's correct, Congressman Davis.
In fact, wasn't it an 8-to-1 ruling?
That's correct, Congressman Davis.
Now, slow down for 1 second, because we have a limited amount of time, and I want to make sure I pursue this. What does that say to you, Mr. Agarwal, that you have presumably trained lawyers who are knowledgeable about the scope of Title VII and the retaliation clause, and your trained lawyers came up with the position that 8 justices rejected? It's not an 8-to-1 liberal court. I think it's thought anecdotally to be a 5-to-4 conservative court, sometimes 6-to-3 on these issues. Who was the one?
Justice Alito wrote a concurrence in that case.
Okay, and he's the new guy. What does it say to you that 8 justices on a conservative court disagreed with the department's interpretation of the retaliation clause in Title VII?
Congressman, at the time the department submitted its brief, 6 circuit courts of appeals, including a majority of the circuit courts that had addressed the issue, agreed with the position that we ultimately took, including the 6th Circuit in that case. Justice Breyer, in his majority opinion, acknowledged that it was a very difficult case.
Well, let me try to put this in some perspective, because I think the chairman used his time wisely to make a very broad point, and I will echo that. Some of us have the expectation that the Department of Justice seeks to thwart racial discrimination against historically discriminated against groups. I don't think that's a radical perspective on my part, that the Department of Justice should seek to thwart discrimination against historically disadvantaged groups. I think that's the primary aim of Title VII. I suppose it's true, as Mr. Franks points out, if I could just briefly finish, Mr. Chairman, I suppose it's true, as Mr. Franks points out, that sure, there are these reverse discrimination cases that emerge, but the thrust of Title VII has been to alleviate discrimination against people who have historically not enjoyed the protection of the law. And I think it's troublesome to some of us when we see the department take narrow interpretations of the retaliation clause, narrow interpretations of back pay provisions in Title VII, narrow interpretations of the Equal Protection Clause, and then when we see the department depart from long-settled, long-standing interpretations, the last thing I would say to you, Mr. Agarwal, we understand that administrations change hands and that your administration is more conservative than its immediate predecessor. Some of us believe that there ought to be a core set of beliefs that the Department of Justice safeguards, irrespective of the ideology or the party that sits in power. And unfortunately, what I think my chairman was saying is that there is some sense that this administration has substituted ideology for analysis and that it is bent over backwards to pull back the protections in Title VII. That doesn't compare well with, for example, the Bush 1 administration, 1989 to 1993. Some of us are sitting on this committee, in fact, all three of us to my right, Mr. Watt, Mr. Scott, and myself, because of interpretations of the Voting Rights Act that were reached notably by an expansive interpretation adopted by Bush 1. What we see with this administration, unfortunately, is a tendency to narrow and to truncate these rights instead of either taking a traditional view or, God forbid, a heroic view. I'll yield back.
Thank you. The chair will now recognize the distinguished ranking member for 1 minute.
Mr. Chairman, thank you. Mr. Chairman, in sincere deference to Mr. Davis, I know that some of the questions he asked were not hostile in any way. However, they were outside the purview or the focus of this committee, since this is on the unemployment or the employment litigation section of the office, which is what Mr. Agarwal oversees. And I just thought it's important to recognize that he really wouldn't be expected to be able to know some of those things, but I appreciate his willingness to get an answer for Mr. Davis. Thank you.
Thank you. I now yield back. I yield 5 minutes.
Mr. Chairman, may I just ask a question? Is this hearing limited to the civil employment section of civil rights? I thought this was a general civil rights division.
It's concentrated on the employment section. We've had a different hearing on some of the others, but it's open to anything on that. It's open to anything on the division. Of course, Mr. Agarwal is only from one part of the division.
I understand that, but did we specify that, or the Justice Department?
Yes, we did.
Okay.
We did in the hearing notice.
All right. Thank you.
This is concentrating on the employment section. We've had a previous hearing. We'll have additional hearings on the Department, Civil Rights Division generally. The division has how many? 7? Has a number of different sections, and we're holding a series of hearings. Gentleman from Virginia.
Is it Mr. Jordan's turn?
He's passed.
Okay, thank you. Thank you, Mr.
Gentleman is recognized for 5 minutes.
Thank you, Mr. Chairman. Mr. Agarwal, is your budget sufficient for you to do your job, or do you need more money?
Our budget is sufficient.
So any shortcomings that you have cannot be blamed on Congress failing to appropriately fund your agency?
We have no funding complaints, Congressman.
Okay. Does your office work on discrimination based on military service so that returning Iraqi veterans could look to you for help?
Absolutely. That falls under USERRA.
Do you find that many National Guard and reservists are having trouble retaining their jobs under the various laws that protect them?
We have seen such instances, yes.
And what have you done?
We have, when the Department of Labor refers a complaint to us, if they are unable to reach a settlement with the employer, we will then investigate the matter ourselves and bring suit if appropriate. We have brought 15 lawsuits under USERRA, including the first ever class action brought by the United States under that statute.
Are any federal agencies guilty of failing to protect the National Guard and reservists' right to their jobs?
Congressman, with respect, that issue falls within I believe it's the Office of Special Counsel. The Justice Department Employment Litigation Section does not have jurisdiction to sue other parts of the federal government.
3,200 referrals. Are those all government agencies that are found by EEOC to be discriminating?
Yes, Congressman.
Do you have the discretion to go after private sector employers?
Not under Title VII, only under USERRA.
Under USERRA, you can go after private sector employers, pattern and practice or individual cases.
Class actions or individual cases, yes, sir.
Have you brought pattern and practice cases involving national origin?
Yes, sir. We've brought 4 pattern and practice cases on behalf of blacks and Hispanics.
If in your own employment practices, could you tell us how many minorities you have who've been hired in the last 6 years? Do you have that information available? If not right now, could you provide it for us?
I have that information for the last 5 fiscal years, Congressman. Within those past 5 fiscal years, 27% of new hires into the division have been minorities. That compares to a national average, as found by the ABA, of only about 9% of attorneys who are minorities. So we've managed to triple the average.
And how do you define minorities?
That's defined by, there's an ABA study, I believe, from 2004.
Does that include women?
I don't believe that it does. No.
And what has happened to the 3,200 referrals minus the handful that you actually pursued? What happens to the rest of them?
Those charging parties are sent a letter informing them that they have the right to bring suit on their own by retaining private counsel or a legal aid agency.
I'm sorry, what is legal aid agency mean?
Well, if some individuals are unable to afford private counsel, we will refer them to a legal aid organization.
Legal Services Corporation?
Something like that, yes.
And they can bring discrimination cases?
Yes.
Thank you, Mr. Chairman. Mr. Chairman,
I thank the gentleman, and I yield now. The gentleman from North Carolina is recognized for 5 minutes.
Thank you, Mr. Chairman. I guess there's a tendency sometimes for us to kind of segment, compartmentalize, is what they used to call it when President Clinton was in office, into little silos here. But I am deeply troubled by something that I don't think is something that we can ignore. We've had testimony from the Attorney General and various people in that office about the politicalization of hirings of U.S. attorneys. And there is a profound article dated July 23, 2006, in which the Boston Globe reporter made some interesting charges, which I would like to go through with you and have you either confirm or refute. He said, in an acknowledgement of the department's special need to be politically neutral, hiring for career jobs in the Civil Rights Division under all recent administrations, Democrat and Republican, had been handled by civil servants, not political appointees. But in the fall of 2002, then Attorney General John Ashcroft changed the procedures. The Civil Rights Division disbanded the hiring committees made up of veteran career lawyers. Are you aware that that happened?
Yes, Congressman.
Okay, all right. For decades, such committees have screened thousands of resumes, interviewed candidates, and made recommendations that were only rarely rejected. Now, hiring is closely overseen by Bush administration political appointees to justice, effectively turning hundreds of career jobs into politically appointed positions. The profile of the lawyers being hired has since changed dramatically. According to the resumes of successful applicants to the voting rights, employment litigation, and appellate sections. Under the Freedom of Information Act, the Globe obtained the resumes among hundreds of pages of hiring data from 2001 to 2006. Hires with traditional civil rights backgrounds, either civil rights litigators or members of civil rights groups, have plunged. Only 19 of the 45 lawyers hired since 2003 in those three sections were experienced in civil rights law, and of those, 9 gained their experience either by defending employers against discrimination lawsuits or by fighting against race-conscious policies. Meanwhile, conservative credentials have risen sharply. Since 2003, the three sections have hired 11 lawyers who said they were members of the Conservative Federalist Society. 7 hires in the three sections are listed as members of the Republican National Lawyers Association, including 2 who volunteered in the Bush-Cheney campaigns. Several new hires work for prominent conservatives, including Whitewater prosecutor Kenneth Starr, Meese, Trent Lott, Pickering, 6 listed Christian organizations that promote socially conservative views. The changes in those three sections are echoed in varying degrees throughout the Civil Rights Division, according to current and former staffers. At the same time, the kind of cases the Civil Rights Division is bringing have undergone a shift. The division is bringing fewer voting rights and employment cases involving systematic discrimination against African Americans and more alleged reverse discrimination against whites and religious discrimination against Christians. There's been a sea change in the types of cases brought by the division, and that is not likely to change in a new administration because they are hiring people who don't have an expressed interest in traditional civil rights enforcement, said one former employee. Do you have any dispute with anything that I have read here?
Yes, I do, with respect, Congressman.
Well, I whispered to my colleague on my left here, Mr. Scott, that I don't see much. I see some gender diversity in this row behind you, but this doesn't look like a civil rights litigating section to me. Now, maybe I'm just stereotyping people. Tell me what about this you disagree with. Maybe that would be constructive. And give us some numbers.
The gentleman's time has expired. The witness
hiring, and give it to us in writing if you would. But give us whatever you want to say in response to what I'm saying.
The witness can respond briefly now and then hopefully more fully in writing.
Sure. A couple of things. First of all, let me clarify my answer about the hiring committees. I understand that allegation has been made. I wasn't at the department in 2002, so I don't have firsthand knowledge.
Well, that's part of the problem. There ain't no experienced lawyers over there. That's part of the point that the article is making.
Sure. In terms of diversity.
How long you been there?
I've been with the department for 2 years, Congressman.
And they sent you over here to testify about what's going on in the employment discrimination area?
I wasn't happy with that decision either, Congressman.
Okay, well, that explains that. You're just as unhappy about it as I am, maybe from a different aspect. But at least we got some reaction out of you. I mean, you know. Go ahead. I'll shut up and let you explain whatever you want to explain.
Let me just say, with respect to diversity in the ranks of the Civil Rights Division, I think we have excellent diversity. The head of the employment litigation section is a Hispanic individual. He's the first Hispanic section.
Give me those numbers in writing. I want to know your general reaction to what I just said to you here, which is that the drawdown of experienced attorneys doing anything other than reverse discrimination cases is, Is there a staff over there who can do traditional civil rights cases? Why would we be surprised if the number of cases is diminishing if the staff is not even attuned to that kind of discrimination?
Congressman, until very recently, 2 of the deputy chiefs in the employment section were African Americans. One of those deputies left because he accepted a promotion to head up another component of the department. And in terms of our cases, we've enforced Title VII, all of its provisions on behalf of all Americans. We've brought 4 pattern and practice cases on behalf of African Americans and Hispanics. We have brought 2 cases on behalf of white Americans.
Well, Mr. Agarwal, the time has expired, and I want to let you answer his question, but his question is not about how many pattern and practice cases you brought. We went through that before. His question is about the drawdown. How many attorneys are still in the division, or in the division, who have experience bringing these types of traditional civil rights cases? That's the question, correct?
Well, that's part of it, I guess. Yeah.
And the rest you can answer in writing, but answer that, please.
A number of them. 2 of our deputy chiefs, including our principal deputy, have been with the employment litigation section for decades. They're long-term veterans.
And how many such people are left?
I don't have an answer as to the average length of tenure.
How many of the people sitting behind you have been with the department longer than 3 years? Everybody that's been with the department longer than 3 years, raise your hand that's on the front row there.
There are 4 people from the department, 2 of them.
They can raise their hand. If you've been with the department more than 4 years, raise your hand. 2 of about 12 or 13,
4.
14.
We have 4 other people from the department here, Congressman.
Where are they? They ain't raising their hands.
No, he's saying that only 4 other people are here from the department. Not everybody there is from the department, apparently.
And the one that did raise their hands with legislative affairs, not litigation.
She's a valued member of the team.
I appreciate that.
The time of the gentleman has expired. Mr. Agarwal, you will submit written answers, I assume, to the questions.
Absolutely.
Thank you. The witness is excused.
Mr. Chairman? I'm sorry. I came back for just this opportunity.
Gentleman is recognized for 5 minutes.
Thank you, Mr. Chairman, and I'll be brief. I do find it interesting that the gentleman on the other side of the aisle, who wanted, in fact, everyone in your department to have less than 2 years, roughly 2 years experience, because they would have had the entire administration change all of you out 2 years ago. So I don't think there's any question that the continuity.
Was the gentleman yield on that point?
Well, sure. What the heck? I've got all the time.
How many of these people are political appointees versus career people?
2 political appointees.
You see, we're talking about drawing down the number of career
and reclaiming my time.
Career lawyers, not political.
Thank you. And
the gentleman from California controls the time.
Thank you. And reclaiming my time. I recognize that opportunities exist for attorneys for a lot higher money outside of what we pay in government. In fairness to the record, I think if we were asked to have people behind us raise their hands and say how long we were able to hold the best and the brightest attorneys working for us, what a surprise. It's very difficult to hold them for a long time because, in fact, every one of them is making a financial sacrifice by working for the federal government rather than private practice every day. I do have one area that, even though I talked about not expanding what we do, but rather doing well what your charter is, I do have one question for you, which has to do with non-military private sector discrimination. As I understand it, you currently, that's the one area that you're limited. That falls to the states, that you can investigate public employees, but you're limited as to private companies' discrimination.
The EEOC has jurisdiction over private employers under Title VII.
Right. And the question I have for you is, when we're looking at the most efficient way to broaden the amount of investigations, the quality of them, and so on, do you think the present makeup is correct? Knowing that the EEOC essentially is an organization that historically gives people the right to sue, but does very few actual enforcements?
That's a very good question, Congressman. With respect, I actually haven't given that much thought. We have a very good working relationship with the EEOC, but I think that's something that we would have to, that's the best allocation. I think that's something we'd have to take back and really think about.
And I would appreciate it, and I'd appreciate it if you don't mind responding both to this committee and with the indulgence of the chairman to the Government Reform Committee. Government Reform and Oversight, because that is a critical question, I think, that is at the heart of today's hearing. I appreciate your telling us what you have accomplished. Well, the majority is telling us what may not have been accomplished to their satisfaction. But we do have an obligation, both on this committee and next door on the Government Oversight and Reform, to look for efficiencies. What are the organizations and the utilization of personnel that are going to give us the highest enforcement of that which we have agreed on a bipartisan basis with the signature of at least one president at some time to do. And I would appreciate, to the extent that you can, and take it back and try to get us full writings. With that, Mr. Chairman, I appreciate the indulgence and yield back the remaining time.
I thank you, and I thank the witness. You're excused. I'd ask the second panel to step forward and take your seats.
It's supposed to be 11, but they lied. They don't count the votes right, and they lie. Just the way it goes.
While they're taking their seats, I will introduce the second panel. Professor Richard Ugelow. Ugelow is a veteran of the Department of Justice, having served 29 years as a trial attorney in the department and rising to the post of senior trial attorney and ultimately Deputy Section Chief in the Employment Litigation Section of the Civil Rights Division. Before joining the department, Mr. Ugelow served his country as a captain in the Army Judge Advocate General Corps. Currently, Mr. Ugelow is a member of the faculty at Washington College of Law, specializing in employment discrimination litigation and clinical legal education. Janet Caldero is a custodian in the New York City Public Schools. She has been a participating witness in an investigation into the New York Board of Education's hiring practices for custodians and was a beneficiary of a settlement entered into by the Department of Justice and the City of New York regarding discrimination in the hiring of school custodians. Eric Dreiband? Eric Dreiband is a partner in the Washington office of the law firm Akin, Gump, Strauss, Hauer, and Feld, and represents companies in civil rights, employment discrimination, and wage and hour litigation. Before joining Akin Gump, Mr. Dreiband served as the General Counsel to the Equal Employment Opportunity Commission and as Deputy Administrator of the Department of Labor's Wage and Hour Division during the administration of President George W. Bush. Mr. Dreiband also served for 3 years as an Associate Independent Counsel in the Office of Independent Counsel Kenneth Starr. He's a graduate of Northwestern University School of Law. Jocelyn Frye is the General Counsel for the National Partnership for Women and Families in Washington, D.C. Ms. Frye's work covers a wide range of employment discrimination and workplace-related issues, including efforts to ensure equal enforcement of employment laws. She currently directs the National Partnership's Workplace Fairness Program, and in that capacity has worked to address employment barriers facing low-income women, including obstacles that make it difficult for many women to transition from welfare to work. She's a graduate of Harvard Law School. Your written statements will be made part of the record in its entirety. I would ask that you now summarize your testimony, or shortly summarize your testimony in 5 minutes or less. To help you stay within that time, there's a timing light at your table. When 1 minute remains, the light will switch from green to yellow and then red when the 5 minutes are up. Before we begin, it's customary for the committee to swear in its witnesses. If you could please stand and raise your right hand to take the oath. Do you swear or affirm under penalty of perjury that the testimony you're about to give is true and correct to the best of your knowledge, information, and belief? Let the record reflect that each of the witnesses answered in the affirmative. You may be seated. Now, let me state before we begin the testimony, there's now a vote on the floor. There are, in fact, 4 votes on the floor. There's 12 minutes remaining on the first vote. The 3 subsequent votes will be 5-minute votes. We will recess for the votes. I ask the members to return as soon as the last vote is called and you have an opportunity to vote so that we can resume with the witnesses. I think we can probably get in Yeah, we'll get in the testimony of one witness at least before we have to go to the vote. Yeah, so I'll begin. So I'll first recognize, in this order, Professor Ugelow.
Good morning, Mr. Chairman and members of the committee, and thank you for the opportunity to testify today. I joined the law faculty at American University following 29 years as a member of the Employment Litigation Section of the Civil Rights Division. I started in the Employment Litigation Section in 1973 as a trial attorney, following 4 years of active duty in the Army's Judge Advocate General Corps. In 1989, I became a Deputy Section Chief in the Employment Litigation Section. I served in that capacity until I was removed in May 2002 by then Assistant Attorney General Ralph Boyd. Today is the most appropriate time to hold a hearing on the oversight of the Employment Litigation Section. In just 4 days, on September 29th, a forum will be held at the Georgetown University Law Center celebrating the 50th anniversary of the Civil Rights Division. The successes of the division over the last 50 years are indeed worthy of a celebration. My testimony today addresses the Civil Rights Division's enforcement of Title VII of the 1964 Civil Rights Act, an act that prohibits discrimination in employment based upon race, sex, religion, and national origin. I am deeply saddened to say that this administration has been severely lax in its enforcement of Title VII. With a little more than 1 year remaining in office, the Bush administration has filed only 47 Title VII lawsuits. By contrast, the Clinton administration filed 92 lawsuits in its 8 years. The Bush 1 administration filed 81 lawsuits in its 4 years, and the Reagan administration filed 99 cases in its 8 years in office. In particular, this administration has been derelict in using Title VII to ensure that African Americans and Latinos are free from employment discrimination. In the first 2 years of the George W. Bush administration, a total of 7 Title VII cases were filed, which I submit is virtual non-enforcement, and likely was interpreted as such by the employer community. It is also noteworthy that in almost 7 years, the employment litigation has filed only 3 pattern of practice or systemic cases that seek to vindicate the rights of African Americans. During the same time, the administration has filed 2 pattern of practice cases alleging reverse discrimination. This administration's record does not fare any better when looking at its use of Title VII authority to file suits based upon individual charges of discrimination. The administration has filed 10 cases that allege discrimination based upon race, and 2 of those cases were reverse discrimination, or 20% of the cases were reverse discrimination cases. Not one of these cases alleges discrimination against Latinos. My review of the section's case filing suggests that enforcement efforts have focused on cases raising claims of religious discrimination. I do not doubt that these are worthy and important cases, and I do not wish to minimize their significance. However, one must ask if those cases are more or less important than acts of discrimination against African Americans and Latinos, and what that says about the department's priorities and its use of available resources. Try as I might, I cannot find a rational reason for this administration's lack of enforcement. Surely it cannot be that there suddenly has been a reduction in employment discrimination in the workplace. I can only conclude that this administration has made a conscious decision to reduce enforcement. I leave it to this committee and to others to determine the rationale for that decision. I urge Congress to maintain vigorous oversight of the Employment Litigation Section and the entire Civil Rights Division in order to ensure that the civil rights laws are fairly and vigorously enforced. Thank you for the opportunity to testify today, and I will be pleased to answer any questions you may have.
I thank the witness. With that, the subcommittee will stand in recess. All members are asked to return promptly after the last vote so we don't hold the witnesses too long, and the committee is now in recess.
doing? Good, good.